what's a principal activity? How is it defined? Because pre- or post-activity to a principal activity, you still have to define what a principal activity is. And so I think, isn't the principal activity work that benefits the employer in some way?
No, Justice Sotomayor, and I think it's important to get two concepts separate. One is work under the Fair Labor Standards Act. And for purposes of that, all you really do need is things that are required by the employer for the employer's benefit that require a minimum amount of exertion. That's the test from this Court's cases. But principal activities is a separate and more demanding test under the Portal Act. And the way I think about the statute is the Fair Labor Standards Act makes all work presumptively compensable. And then only when you get to something that is arguably post-preliminary or preliminary do you have to ask a question that involves principal activities. Because if you have compensable work and it's not even arguably preliminary or post-preliminary, it's compensable without regard to the Portal Act. But when you get to the Portal Act, then you have to look, is this a preliminary and post-preliminary activity? And if it is, then it's presumptively non-compensable unless it's integral and indispensable to a principal activity.
Well, let's take Justice Ginsburg's hypothetical. Let's assume that it takes 25 minutes to check out and that it would be very easy for the employer to hire a few more checkers and make it 5 minutes. Just assume that that's the fact. Why isn't the long line caused by very few checkers for the benefit of the employer? It's for the benefit of the employer to hire fewer checkers.
It might be for the benefit of the employer in that set of circumstances, Justice Kennedy, but that doesn't make it not post-preliminary activity and not compensable. And if you look at the universe of all non-compensable time under the Portal Act, I think in every instance you could say if the employer only did more, he or she could reduce that time. And so if you go back
to move his plant, for example, to be closer to the city where the employees live, right? So it takes him an hour to get to work. It's his fault that it takes him an hour instead of just 10 minutes. He should move his plant. It's just a matter of cost, right?
That's exactly right, Justice Scalia, and you can take it from the commuting time to the commuting time internally. If you go back to those trams in the coal mining cases, if the employer added more trams or more tram drivers, presumably that travel time would be reduced.
Is it always irrelevant to the analysis that it's for or not for the benefit of the employer?
It is irrelevant for the Portal Act analysis. And as I said, it's not irrelevant to the analysis at all because the fact that it is for the employer's benefit is part of what makes it compensable work presumptively or work under the Fair Labor Standards Act. But when you get to applying the Portal Act, that is activity that even though it's work, even though it's required by the employer and even though it's for the benefit of the employer, is nonetheless non-compensable by the terms of the Portal Act. And if I could just continue
that's not quite right, because if the employer requires you to put on a particular outfit that you can't do the work without, we've said that's compensable.
I don't think you have a case.
But donning generally isn't. So I'm not quite sure how you can take out that element from this analysis.
Justice Sotomayor, I don't think there's a case of this Court that says just because the employer requires something that would otherwise be superfluous, that it therefore becomes integral and indispensable. And so I would actually take —
I agree with you. It can't be superfluous. It can't be something that's for the benefit of the employee. Putting on clothes to keep yourself from being splattered with non-harmful substance is for the benefit of the employee. But
take something where a particular employer has an idiosyncratic view and actually wants their employees to have a certain colored smock or a certain piece of equipment that's not actually particularly integral and indispensable to anything. I don't think anything in this Court's cases would say just because the employer required it, it is therefore compensable. And I think if you go back to the quintessential example of something that is post-preliminary and non-compensable, the time clocks, the checking out process, all of that is required by the employer and for the employer's benefit. And so I don't think you can meaningfully distinguish the exit screening from those quintessentially post-preliminary, non-compensatory things.
Indispensable. hardly anything is indispensable.